People v. Fuentes. Counsel?
May I proceed?
Sorry?
May I proceed?
Yes, of course.
Good afternoon. May it please the court. My name is Amanda Schaefer from the Office of Laurette Mullery on behalf of the appellant, Mr. Fuentes. Disciplinary records relate to the subject matter of the
Counsel,
case.
do you want to save time for rebuttal or no?
Yes, Your Honor. May I request 3 minutes for rebuttal, please?
Yes.
Thank you. Disciplinary records relate to the subject matter of the case when they relate to the credibility of a witness in the case. Further, Section 245.20 does not limit the people's discovery obligations based upon the outcome of an internal affairs investigation. Here, the appellate term's constricted reading of Section 245.20 contravene the plain language of the statute and the legislative history underlying the discovery reforms. Because the people failed to exercise due diligence to obtain the disciplinary records for the arresting officer, this court should reverse. First, I would like to address the amendments which became effective to Article 245 last month. The plain language of the amended statute supports that the legislature only intended for it to apply prospectively. In Gleason versus Gleason...
Do they apply?
Excuse
Do
me?
they apply to the case, to the amendments?
No,
The
Your Honor.
amended statute apply?
No, Your Honor. The appellant's position is that the amendments do not control the outcome of this case. And when you look at the plain language of the amended statute, it provides that it applies to pending criminal actions. But a criminal action is a proceeding that occurs before a criminal court. And in Section 1010 of the penal law, a criminal court includes the superior and local courts, but not a court exercising appellate jurisdiction. And in People versus Colwell, the Third Department held that an appeal is not part of a criminal action or criminal proceeding. Therefore, I believe that this court can resolve the retroactivity issue based upon the plain language of the amended statute.
Can we talk about what you think the amendment, adding the related to the subject matter into that subsection K, what that effect is? What do you think?
Yes, Judge. Even though appellant believes that the outcome of this appeal should be decided based upon the pre-amendment statute, the amendments to Article 245 support appellant's position that the legislature intended to afford defendants broad discovery of impeachment materials. And the phrase relate to the subject matter of the case. Specifically, the plain language of that phrase supports that impeachment material can cover even bad acts that don't involve the defendant or the defendant's case.
Well, how is that? If you're saying that related to the subject matter of the case seems to me is a limiting clause. You don't see it that way?
No, Your Honor, because when you think about what the case means, what's included in the concept of a case, it includes the people's witnesses. And in order for the people to meet their burden of proof, their witnesses need to be credible. In this case, the arresting officer was...
So is there any limitation as to what you can get to a witness called by the people?
Well, the statute provides that the defense should receive disclosure of all evidence and information, including that which is known to police or other law enforcement acting on the government's behalf, that tends to impeach. And this court's prior...
So would you agree at a minimum it's limited to tends to impeach?
Yes, that is the plain language of the statute, Your Honor. This court's decisions in People versus Walker and People versus Smith support that impeachment material can derive from prior bad acts that don't involve the defendant or the defendant's case. In People versus Smith, this court held that defendants should have been permitted to cross-examine law enforcement witnesses regarding prior bad acts alleged in federal civil rights lawsuits, although in some of the cases in Smith, the court did find that the error was harmless. And when we look at the plain language of 245.21K, there are several aspects of the statute that...
But isn't there an exoneration here?
Yes, Your Honor.
So why is it still impeachment evidence?
So the police department here did determine the allegation to be exonerated, but the underlying allegation actually was made in a Section 1983 federal civil rights lawsuit. And in People versus Smith, this court held that...
And was that information provided in another manner?
So the people in this case did provide us with a copy of the plaintiff's complaint when they filed their supplemental certificate of compliance on July the 28th.
So what other information do you think you would have needed?
Well, if you look at the plaintiff's complaint, the only place where the arresting officer is named by name is in the caption of the case. But in the factual allegations, the complaint does not specify what she's alleged to have done. It's only when we later receive these associated internal affairs records that we learn exactly what she was alleged to have done. And just to finish my answer to Judge Halligan's question, nothing in the plain language of Section 245.20 limits the people's disclosure obligations based upon whether the police department exonerated the officer or deemed the allegation unfounded. And I would liken this to a disposition where the alleged prior bad act just was not formally proven at trial. It can still...
Wait, how is that the same as an exoneration?
Well, an exoneration issued by the Internal Affairs Bureau means that the alleged act did occur, but that the police department found that it was legal, necessary, and proper. And if you look at the plain language of Subdivision 1K, it still requires the prosecution to turn over the information, even if the prosecutor does not credit the information.
And where are you getting that information that that's what exoneration means?
That's the definition that was set forth in case law, including the Suffolk County Supreme Court's decisions in People versus Randolph and People versus
So that's
Portillo.
specific to the Suffolk County Police Department?
That's my understanding, yes.
What would be the outcome if it was determined that the alleged acts didn't even occur? Would that be unfounded or something like that?
My understanding of the definitions as set forth in those cases is that an unfounded allegation is when the police department finds that there's evidence to show that the act did not occur.
So that would be the correct designation for a finding that it didn't even happen at all.
That would be the designation for the police department's view that it did not happen.
And would you view that as discoverable or no? If
the
it was labeled
underlying-
unfounded?
If the underlying allegation tends to impeach, then yes.
Even if the conclusion is that it was unfounded, and as you just indicated, that suggests that the department concluded it didn't occur?
Yes, even as long as the underlying allegation itself has a tendency to impeach. And in People versus Walker, this court defined impeachment as a form of cross-examination whose purpose is in part to discredit the witness and demonstrate to the finder of fact that the witness is not credible. One way of achieving this is to demonstrate through questioning that the witness has been guilty of prior criminal, immoral...
But what if there's no determination that that person was guilty of some prior bad act?
I would not liken an internal affairs disposition to an acquittal after a trial or maybe a finding of no liability.
So are
after.
you suggesting essentially that if there's an accusation made, that every document contained in an officer's IAB file must be turned over?
Well, if the accusation tends to impeach, that is.
Okay, so what do you define that as?
I would turn to this court's well-settled case law on the definition of impeachment in People versus Walker. As I had alluded to previously, this court found that it is something, it can be demonstrated through questioning
What
that
if
the
it's,
witness has
what if
been...
it's an anonymous accusation?
May I ask Your Honor to please repeat that?
Or what if it's an anonymous accusation that's in the file?
I don't believe that the Section 245.20 limits disclosure based upon the anonymity of the complainant.
And what if it's something where the complainant completely retracts and says, I made this up?
I believe that that could be something that the prosecutor should also have to turn over. However,
Why is that impeaching if it's determined that it was in fact made up?
Well, at bottom, because Subdivision 1K says that the prosecutor must turn over the information irrespective.
What if the complainant is prosecuted for making a false police report and convicted of that?
Then I believe that that would be akin to an acquittal after a trial, which this court has previously held, would not be proper fodder for cross-examination. In this case,
Counsel, before you do that, can we just step back, and I'm just trying to get an understanding of how the statute works, which is a little, honestly, confusing to me. So this is a certain time limit on this discovery. Tied to what?
tied to the people's ability to declare ready for trial.
Ready for trial, which may happen in a certain number of days, depending on the charge, right? So as I read the statute, there's 3 requirements, and we've been talking about 2 of them, which is it needs to go to some impeachment value, and this whether or not it needs to be related in some way to the case, right? As a possible third, which I understand is disputed here. But it also says testifying prosecution witness. As I understand that, I'm getting ready for hearing, I have material on a testifying witness, whatever it is in suppression, I turn it over. So how do you know it's a test? I understand that's not here, but I'm just curious, what's the test for testifying witness?
Judge, the appellate term in People versus Hamazane, which is the decision that we were relying on in the court below, actually answered this question by saying that the people have to disclose the disciplinary records for all potential law enforcement witnesses who are listed in their certificate of compliance. But that the court doesn't need to reach that question in this case because here Officer Congito was
Well, it does sort of go to what is a reasonable expectation in this statute, right? Because the broader you cast the net for potential testifying witness, the more difficult it seems to me it will be to collect relevant materials that won't get you thrown out on speedy trial grounds, right? So if we define the universe without related to the case, right, you have a bigger universe of potential witnesses than if we do. So should that factor, does say testifying witness, relate somehow to how we view whether related to the case applies to this subdivision or not?
I think to answer that question in a vacuum, again, without reference to any, specific case facts, if it were not a witness that were essential to the people meeting their burden of proof, it might make it a closer call. But this is not that case.
I'm not so much interested in a particular case as in a rule, because the broader the rule, the more onerous the burden in a relatively short period of time and one that has fatal consequences for the prosecution's case. So should we, through that lens, view whether there is that modification of related to the case?
Well, in this case, I think that language is satisfied because Officer Congito was a necessary witness for the people to call in order to meet their burden of proof. And the other important aspect of this statute is the presumption in favor of openness, which is codified in Subdivision 7. And notably,
But isn't this really a question, I think, just to piggyback on what Judge Garcia is asking you, a question of timing? Because why doesn't it make sense that the legislature would decide that the information that's tied to this case gets handed over in a very expedited fashion within whatever it is now, 25, 30 days? But then over the long term, information that the people find out, if they determine that another witness will be testifying, that the defense will be entitled to it. It's not like the argument isn't that the defense won't be entitled to it. The argument is it automatic discovery? Is that information to be handed over within a relatively short period of time?
yes, Judge, I believe that first the concerns about cases getting dismissed because something isn't turned over, the statute provides that the statement of readiness, the people's certificate of compliance, and their statement of readiness can't be invalidated unless, again, they don't exercise due diligence and make reasonable inquiries. So that will, of course, factor into the analysis before we get to a stage where a court would consider dismissing a case. And just as a general matter, the people also would have had to have exhausted their speedy trial time as well. In this case, there is, Officer Congito was a necessary witness for the people to call in order for the people to meet their burden of proof. And also, if you look at the first four words of Subdivision 1K, it provides that the people should disclose all evidence and information. And the respondent here argues that the legislature intended to codify this court's decision in Garrett, which of course was a decision about the people's obligations under Brady versus Maryland. If the legislature wanted to codify the people's Brady obligations, they could have said the people must disclose evidence and information which is favorable to the defense and which is material to either guilt or punishment. They could have just stated the Brady rule. But here, the legislature intended to go beyond the people's constitutional discovery obligations and provide defendants with broad disclosure of impeachment material. And Garrett is distinguishable also because the legislature built in its own possession provisions into 1K and subdivision 2. 1K includes information that's known to the police or other law enforcement acting on the government's behalf. And
Again, I think my quibble isn't with Garrett generally, it's just tied to this automatic discovery. Why is it that you think your reading is better, that the prefatory language related to the subject matter of the case has no application under subdivision K?
No, I believe that it does have application either under the pre-amendment or amended statute. I believe that that's the language the legislature used to indicate its intent that this subdivision be construed broadly. And even if we look at the amended statute, I believe...
But just to stay on the on the prior statute, so then your view is that relates to the subject matter of the case, encompasses any of the material that is at issue in this case because it could be impeachment evidence?
Yes, Judge, specifically because in the opening clause of the pre-amendment statute, the opening clause ends with the words including but not limited to. So it's our position that the legislature included by definition all of the categories of automatic discovery in what relates to the subject matter.
So then what exactly is your position about how the words relating to the subject matter of the case interact with subdivision K, if I have the number right?
With respect to the pre-amendment statute,
Yeah.
I believe that subdivision 1K is included by definition within the scope of what's related to the subject matter of the case. Even looking at the amended statute, it's clear that the legislature intended for subdivision 1K to have a broader interpretation because they narrowed the scope of other subdivisions with narrower language relate to the subject matter of the charge. Your Honor,
But if sorry, may I just, one quick, if that's right, it seems like there would be a way of drafting the statute differently, which would be to segregate K and not put it as something that is subsumed under relating to the subject matter of the case. Wouldn't that have been a clearer way to draft it?
I see that my light is on. May I answer the question?
Please do, yes.
No, Your Honor. I think that the construction that the legislature used supports the broader application, and recently the Appellate Division in People versus Coley adopted this interpretation. In order to relate to the subject matter of the case, it needs to relate to the credibility of a witness. I will reserve my remaining arguments for rebuttal if there are no further questions.
Thank you.
Good afternoon, Your Honors. Ms. Schaefer. I am ADA Carla Lato for the respondent. We are here asking that this court make a reasonable determination that IAB reports and files that are unrelated to the subject matter of a defendant's case are not subject to automatic disclosure under 24520.
Old statute or new statute?
Your Honor, it is our contention that the new statute can be applicable in this case since the appellate term had reinstated the accusatory instruments in its decision in 2023. However, whether you look under the old statute or the new statute, it is our contention that 24520 1K4 is read identically. However, I think that we need to look at the 2025 amendments for reinforcement as to what was the legislature's intent under the 2020 amendments.
Can I ask you just on the 2020 amendments, what's your response to the argument that your reading would result in a curious interpretation of subsection P and subsection Q. I think that the Gale House suggests that.
One moment, please. The statute, if you look at the practice commentaries of the statute under 2020, it does reference subsection K as including a codification of Brady and Giglio. And if you look at what has been required to be turned over with regard to impeachment material under Brady and Giglio, the people have only been required to turn over some basic information that would tend to impeach. It has never been required that we turn over entire files. If you look at the people putting forward a defendant who has, as a prosecution witness, who has a prior criminal record, we are only required to turn over a disposition. We are not required to turn over the entire underlying criminal file related to that certificate of disposition. And it's our contention that with regard to a police officer who is a prosecution witness, there should be no different standard. What I would like the court to note is that the enactment of this automatic disclosure statute was for the purpose of expediting the disposition of cases. It was not to broaden the scope of discovery. It was encompassing the scope of discovery. And discovery has never, when it comes to impeachment material, has never extended to the disclosure of collateral or extrinsic evidence. In this case, although it was not necessary, the people did turn over the exonerated report of Police Officer Congedo. That report, it is our contention, had absolutely no value as impeachment material. And because it did not have the value of impeachment.
Did the prosecution at the time, I just want to follow up on your point there, at the time tell the court that it did not view that it had any duty and obligation to turn that over? In other words, did it preserve an argument that it had no duty to do so?
We did state that we only had a duty to turn over substantiated and unsubstantiated reports. So, and we did go further, I believe, in our response papers to the motion to dismiss, that there was no obligation to turn the report over. And because we had no obligation to turn the report over, the trial court need not reach the issue of due diligence, although we did argue that we did act with due diligence. I would also like the court to consider, in conjunction with the automatic discovery statute, CPL 24555. Now, under automatic discovery, it was required that the prosecutor offices set up some sort of an exchange, a portal, a communication between all of the different law enforcement agencies with the prosecution office. And under 24555, the legislature stated that law enforcement is to make available files related to the investigation of a case or the prosecution of defendant. It does not state that full IAB files are required to be disclosed. . The IAB report exonerating Officer Congedo was unrelated to this specific case, and it did not show that there was any immoral, bad act, conduct committed by the police officer.
Well, why wouldn't the credibility of a witness relate to a case?
Credibility of a witness does relate to a case. However, there needs to be a good faith basis in order to challenge that credibility. And an exonerated report on its face does not provide a good faith balance.
Well, let me ask you this. Suppose that there was an allegation that this officer did something in connection with this case, that she used excessive force, or that she, let's say it was a drug bust, that she took money, and it was this case. Do you think in that scenario that the people would have to turn over any information within the automatic discovery time period?
Yes, because that would be related to the subject matter of the case.
Okay, so then if it didn't relate to the subject matter of the case, is your position that it might have to be turned over, just not within the expedited time period?
At some point, it would have to be turned over to fulfill our Brady-Giglio obligations, yes. If the court has no further questions, thank you.
Thank you.
May I proceed?
Please.
Thank you. The respondent's proposed construction of the statute would result in defendants being entitled to less material than they are normally entitled to under constitutional standards.
But what about the fact that she mentioned it's just a matter of timing, not that information that otherwise would be discoverable is not turned over, it's just a matter of timing?
Well, their interpretation is that it wouldn't be automatically discoverable under the statute, but it's our position that the plain language of the statute, which again is designed to incentivize compliance with discovery requirements in order for them to declare ready for trial, supports that he is entitled to it. And in People v. Wright, this court decided that a defendant was entitled under Brady to information that the complainant was a confidential informant for the police in prior cases. And that provided a motive for why the police in that case believed the complaining witness and not the defendant. So that information that the complaining witness was a confidential informant related to prior cases.
I'm sure I'm not clear. I may have missed it, so my apologies if you have to repeat. What is the response to the timing question from Judge Troutman?
Subdivision 1K,
Yeah.
unique from all the other subdivisions in 245.20, requires the prosecution to turn over the material under 1K expeditiously upon its receipt, even before their time for automatic discovery lapses. And that's what the legislature provided for in this case.
But I thought you said that this results in less discovery than what had previously been available, and I thought that the response was material has to be turned over, just not in the early phase, but later. So what material exactly is not available to a defendant at any point in the case, at some point in the case, that would have been available previously?
Well, Your Honor, the respondent's proposed construction of what relates to a subject matter of a case would exclude all impeachment material that occurred in incidents that are not involving the defendant specifically.
Is that a function of timing or whether it ever gets turned over?
My understanding of the arguments made is that it's their position that that relates to its discoverability, not just to the timing.
You mean with respect to other events outside the scope of the case, yes?
Yes.
Okay.
And ultimately, it's the defense attorney who's in the best position to analyze and assess the weight of the impeachment material, because the defense attorney is the single-minded advocate for the defendant, knows the defense's trial strategy, and knows best how that information could be used. I just want to touch upon what was mentioned about the decisional law in Suffolk County at the time this motion was being litigated. The people did rely on the Randolph decision from the Suffolk County Supreme Court. But that decision, first of all, it doesn't address squarely the situation that we have in this case, where there's a Section 1983 lawsuit also involved alongside the internal affairs investigation. Under Smith, the allegations that are memorialized in the internal affairs records are related to allegations of tortious conduct made in a federal lawsuit, and so they would have been proper fodder for cross-examination. And finally, I just wanted, excuse me, Your
Go
Honor.
ahead and finish your thought.
May I
Yes.
sum up? Thank you. Under Section 245.55, Subdivision 1, that subdivision specifically requires the people to maintain a flow of information to obtain discoverable material, and it specifically references Subdivision 1K in its language. If there are no further questions, I would rest on the brief submitted.
Thank you.
Thank you.